If you have been seeing posts saying the White House just signed a brand new immigration law that changes green cards, H-1B, and DACA on January 30, you are not alone. Millions of people are anxious right now because the claim sounds specific, urgent, and scary. Here is what I am going to do in this video. First, separate what we can actually verify from what we cannot confirm yet. Second, explain how changes like this would normally show up in real life and what proof you should look for. Third, give you a practical checklist for protecting your status, your job, and your travel plans without panicking or falling for scams. Here is the key. Big immigration changes rarely take effect overnight without a trail of official evidence you can check yourself. And that trail is exactly what most people forget to look for. So let us slow this down and make it clear. The viral claim is that a new law called the Immigration Status Verification and Accountability Act of 2026 was signed at the White House, and that it creates three major changes. 1. An 18-month status verification system for permanent residents. 2. Quarterly employer reporting requirements for H-1B sponsors. And 3. A shortened renewal window for DACA recipients, with changes starting January 30. Those are very specific details. The problem is, I cannot independently verify from your message alone that this law exists, that it was signed, or that these exact requirements have been officially implemented. And I will not pretend otherwise. So instead of repeating rumors, we are going to focus on two tracks at the same time. Track 1. What you should check today to verify whether something is official. Track 2. If a change like this were implemented, what would it likely mean in plain English for green card holders, H-1B workers, and DACA recipients, and how you can prepare in a safe way that helps you, even if the rumor turns out to be false. Let us start with verification, because this is where people lose time and sometimes money. When a law is signed and it changes immigration processes, you typically see multiple forms of official breadcrumbs. For example, you see a public announcement on official government websites. You see agencies like USCIS or DHS publish guidance. You often see changes in forms, instructions, policy manual updates, and sometimes a Federal Register notice if a regulation is involved. Employers also typically receive compliance guidance, and there is usually a period where agencies explain how the rule will be enforced. Here is the part most people miss. The internet will give you a date like January 30th, but the practical question is, what happens on January 30th in the real world? Does a USCIS online account prompt change? Does an official portal open? Do forms update? Do employers get a compliance bulletin? If none of that exists, treat the claim as unconfirmed until you can see official sources. So what can you do right now, today, without any special access? First, check uscis.gov newsroom and alerts. Second, check dhs.gov press releases and any published fact sheets. Third, check the Federal Register for any immigration-related rules that match the claim. Because if new verification cycles or employer reporting were created through regulation, you would usually see something there. Fourth, check whether any official forms, instructions, or policy manual pages were updated to match the new requirements. Fifth, if you are in an employment category, check credible employer guidance channels from official sources or recognized legal organizations, because employer reporting changes typically get guidance quickly. Now, if you do that and you see nothing, that does not prove something is impossible, but it does tell you one important thing. You should not make irreversible decisions based on viral posts alone. Not quitting a job, not canceling travel, not paying a stranger to file something, not handing out your A number and personal documents to someone claiming they can register you. That is how scams spike around these stories. Myth versus reality moment number 1. Myth. If a new law is signed, your status can be canceled immediately if you do not do a new verification step by a random deadline. Reality. Lawful status in the US does not usually get wiped out overnight by a surprise social media deadline. Even when rules change, agencies typically define procedures, provide notices, and there is a process for compliance, and often there are protections, appeal paths, or at least a way to cure problems. Now, could a new law create new obligations? Yes. But the way it would play out is through official communication and enforceable procedures, not just a headline and a countdown. With that said, I want to address the 3 claimed changes because even as a hypothetical, it helps you understand what to watch for and how to protect yourself. First, the claimed 18-month status verification system for permanent residents. In plain English, this would mean that every 18 months, a permanent resident might have to confirm identity and status information through a process, potentially similar to revalidation, and there might be triggers for review if something does not match. If this ever became real, the biggest questions would be, what counts as verification? How would you complete it? What documents are required? What happens if you miss a cycle? And what happens if a database mismatch flags you? Here is the detail that changes everything. Is the verification tied to travel, to employment, to renewing a card, to accessing benefits, or is it a standalone requirement for everyone? Those are very different impacts. If it is tied to a specific activity, fewer people would be touched immediately. If it is universal, it would be a massive operational change, and you would almost certainly see clear USCIS guidance and new online tools to manage it. Second, the claimed quarterly employer reporting requirements for H-1B sponsors. In plain English, that would mean employers would have to regularly confirm details about your job, worksite, salary, duties, and possibly continued employment. Employers already have obligations around H-1B conditions and changes, and there are existing compliance frameworks like public access files and labor condition application requirements. A new quarterly reporting requirement would be a major additional compliance burden, especially for large employers with many H-1B workers. So, if a claim like this were true, you would likely see major employer advisories, HR updates, and clear instructions on where to file those quarterly reports, what form or portal to use, and what penalties apply for late or inaccurate reporting. Third, the claimed shortened renewal window for DACA recipients. In plain English, that would mean you would have less time to submit a renewal before your current period expires. That matters because timing affects gaps in work authorization and the ability to keep a driver license in some states. The biggest questions would be, what is the new recommended filing window? Does it change forms or fees? Does it change evidence requirements? And how does it handle people already in process? Again, if this were official, it would show up quickly on USCIS DACA pages, in renewal guidance, and in frequently asked questions. Now let us do a clear who is affected versus who is not, because confusion spreads fast. If the claim were implemented as described, green card holders would be in the first bucket. That includes lawful permanent residents with a 10-year card, conditional residents with a 2-year card, and people in the middle of replacing or renewing a card. Edge case: people who are permanent residents but do not have a current card in hand because it is expired, lost, or in replacement process. They are still permanent residents, but documentation issues can make life harder, especially for travel and employment verification. Next bucket: H-1B workers and their sponsoring employers. The worker is impacted, but the compliance action would often fall on the employer. Edge case: H-1B workers on a cap-exempt employer, H-1B workers in the middle of a transfer to a new employer, and people working at third-party work sites. These are the situations where reporting, location changes, and mismatched data are most likely to create trouble. Third bucket: DACA recipients, especially people with work authorization renewal timing concerns. Edge case: people who have an EAD based on another category, or people with pending renewal cases. In any change, transitional rules matter. Who would not be affected by these specific claims? U.S. citizens would not be subject to immigration status verification as immigrants, though they may still face identity verification in other contexts. Visitors on B visas, students on F1, or other categories were not mentioned in the claim, so you should not assume it applies to you unless official guidance says so. And very importantly, family members in mixed status families should not assume everyone has the same requirement. One person in the household might be affected, another might not. Here is micro hook number 1. The biggest risk is not a new rule itself, it is doing the wrong thing quickly because you are scared. That leads to avoidable denials, gaps in work authorization, or travel problems. So let us talk about real-world consequences, because that is where policy turns into stress. For green card holders, the immediate stress points are usually travel and employment verification. Travel. If a new verification cycle existed, you would want to know whether CBP officers at the airport could see your verification status, whether a mismatch leads to secondary inspection, and what documents you should carry. Employment. Employers do I-9 verification and re-verification in specific situations. A new system could create confusion if employers think they must re-verify everyone, which is not how I-9 typically works. For H-1B workers, the stress points are job changes, promotions, worksite changes, and payroll details. If employers had quarterly reporting, any discrepancy could trigger questions. This does not automatically mean status loss, but it could trigger requests for evidence or compliance reviews. For DACA, the stress point is timing. A shortened renewal window could mean you must be more precise about when you file, because filing too early or too late could cause processing timing issues depending on how the rule is designed. Myth versus reality moment number 2. Myth. If you get selected for a status review, it means you did something wrong. Reality. Many reviews are triggered by data mismatches, address changes, name variations, system errors, or routine checks. A review is a process, not a verdict, but you should respond carefully and keep good records. Now let me give you an example scenario so you can picture how this could play out. Example scenario number 1. Maria is a lawful permanent resident who travels internationally to see family. She saw a viral post about an 18-month verification requirement and panicked. She almost canceled her trip. The safer approach would be: confirm whether any official USCIS or DHS guidance exists. Make sure her physical green card is valid. Bring standard supporting documents that show ties to the U.S., like a copy of her lease or mortgage statement and recent pay stubs if applicable. And make sure her address is current with USCIS if she is required to report changes. If a new verification portal existed, she would complete it using official links only, not a link from a social media comment. The goal is to reduce risk without overreacting. Example scenario number 2. Daniel is on H-1B and his employer is moving him from one client site to another. He sees the claim about quarterly reporting and assumes he has to personally report the change every quarter. In most employer-driven systems, the employer is the reporting party. The safer approach is, he asks HR in writing what the company is doing to remain compliant. He keeps copies of his offer letter, pay stubs, and work location details, and he does not rely on a random consultant promising to register him for a fee. If there is a real new requirement, employers will need a process, and you want your records aligned with what the employer reports. Now, why do claims like this happen and spread so fast? A few reasons. 1. Immigration is complex and high stakes, so people share quickly to protect others. 2. There are real historical examples where policy shifts did change procedures, and people are primed to believe the next shift is imminent. 3. Scammers exploit urgency, especially around dates like January 30, because a deadline pushes people into paying for help. And 4. Government processes are often slow and confusing, which creates an information vacuum that rumors fill. Here is the key. The existence of anxiety does not prove the existence of a law. So what should you do now? I am going to give you a practical checklist that is safe whether or not this specific law is real, because it focuses on fundamentals that protect you in almost every immigration situation. Do this. 1. Create or log in to your official USCIS online account if you have one, and make sure you are using the real uscis.gov site. 2. Organize your core documents in one secure place. Passport ID page, visa pages if applicable, I-94 if you are a non-immigrant, your green card front and back if you are a permanent resident, your EAD front and back if you have one, your most recent approval notices, and copies of any pending receipt notices. 3. Confirm your current mailing address and keep proof of it. If you have a legal obligation to report address changes, follow the official method and keep the confirmation. 4. For workers, keep a simple employment packet, your offer letter, job description, last 3 pay stubs, and a letter from HR that confirms job title, worksite, and salary. You do not need to hand this to anyone proactively, but having it ready helps if questions arise. 5. If you have travel coming up, take a breath and plan like a professional. Check your document validity. Check whether you have any pending applications that could affect travel, and consider postponing only if you can confirm a real policy change that affects your situation. Avoid this. 1. Do not click registration links from social media posts claiming to be a new government portal. Type the official website yourself. 2. Do not pay anyone who promises guaranteed compliance slots or fast-track verification. That is a classic scam pattern. 3. Do not file duplicate applications out of panic, because duplicate filings can create confusion, fees, and delays. 4. Do not assume your employer knows the truth. Some HR teams may also be confused by rumors. Ask for official source links. 5. Do not ignore official mail. If you receive a real notice, deadlines matter, but verify that the notice is legitimate and corresponds to a real case. Myth versus reality moment number 3. Myth. You have to carry every immigration document with you at all times, or you are out of status. Reality. Different categories have different expectations. What matters most is that your status is valid and that you can produce documents when required. Carrying originals everywhere can increase the risk of losing them. For travel, yes, carry required documents. For daily life, keep originals secure and carry copies if needed for practical reasons. Now, what should you watch next, especially with the January 30th date being repeated? Watch for these concrete signals. 1. Official USCIS announcements or alerts that mention new verification cycles, new reporting systems, or changes to DACA renewal guidance. 2. Updated USCIS web pages for green card holders, H-1B, or DACA that specifically explain new requirements. 3. Updated forms or instructions. If a new periodic verification exists, there is usually a form, portal, or process description. 4. Federal Register notices that outline implementation details and dates if regulations are involved. 5. Credible reporting that links to primary sources, not screenshots without context. If you see those signals, then the conversation shifts from rumor management to compliance planning. At that point, you want to ask very specific questions. Who has to do what, by when? How to do it? What happens if you miss it? And what proof you should keep? Here is the part most people miss. Even if a requirement is real, the biggest practical issue is often not eligibility, it is logistics. Portals crash, mail gets lost, employers misunderstand, and processing backlogs create gaps. So the best preparation is always the same. Keep your records clean, keep your address current, document your employment, and use official sources. Let us do one more quick. If you are in X group, do Y segment. If you are a green card holder and you have international travel planned in the next 60 days, do this. Check your card validity, carry your card and passport, keep a copy of key documents in your phone securely, and monitor official CBP and USCIS updates for any new entry procedures. If you are on H-1B and your job situation is changing soon, do this. Communicate early with HR, get changes in writing, keep pay records, and ask whether any new compliance steps are coming from official guidance. If you are a DACA recipient with an expiration date coming up, do this. Check current USCIS guidance on recommended filing timing. Keep copies of your prior approvals, and plan for processing time variability, because even small timing shifts can affect work authorization continuity. Now let me be very clear about what I am not doing. I am not confirming that this specific act is real, or that January 30th is a real enforcement deadline. From the input, we only know that this is being claimed and shared. Until you can match the claim to official sources, treat it as unconfirmed. But we can still use the moment to get you prepared in a way that helps regardless. Final recap. 1. Viral claims about a newly signed immigration law need official verification before you act. 2. If a new verification system for permanent residents, employer reporting for H-1B, or DACA renewal timing changes were real, you would expect clear USCIS and DHS guidance, not just social media countdowns. 3. Your safest move today is to organize documents, keep your address and records accurate, and avoid scams and duplicate filings. 4. Watch for concrete signals, official announcements, updated guidance pages, form changes, and Federal Register notices. 5. If you are traveling, changing jobs, or nearing a renewal, plan conservatively and confirm information through official channels. If you found this helpful, subscribe and turn on notifications, because as soon as there is verifiable guidance or a real published change, I will break down exactly what it means, who is affected, and what steps to take. And remember, do not panic. The goal is to be prepared, not frightened.